Hello again, Pastor Vince with Clergy in Support of the Second Amendment. I've been saying for quite a while that the Supreme Court case that was just decided was going to result in the invalidation, the striking down of about 90% of gun laws in the restrictive states like California and New York. Now, you may think that's extreme. I know a lot of people did prior to the ruling, probably fewer now. But I contend that there's no better way to make your point than to let somebody on the other side make it for you. So that's what I'm going to do today. That's why I want you all to meet UCLA law professor Adam Winkler. He is a constitutional expert specializing in the First and Second Amendments. He's very well known for having written the book Gunfight: The Battle Over the Right to Bear Arms in America, which was written after the historic Heller and McDonald decisions. He wrote it in 2013. Now, Professor Winkler is by no means a gun rights advocate like I am. He is a gun control advocate. Now, I think he's an honest gun control advocate, but he's a gun control advocate nevertheless. So let's see what the good professor has to say about last week's ruling. Most of this information comes from a SF Gate article. It's a website. You can Google it and find this article quite easily. First, let's see what he has to say about concealed carry in California. While the Thursday opinion does not directly wipe out the concealed carry restrictions in California, challenges to such laws are now likely to succeed. In California, concealed carry permits are granted by local law enforcement agencies, some of which are quite restrictive. Specifically, 37 counties in California issue on a virtual shell issue basis, and the remainder of the 58 are quite restrictive. They happen to be the ones in high population areas. So expect a dramatic increase in permits granted in large cities such as San Francisco and Los Angeles. Now, moving forward to the issue of other laws, because I think we all know that basically may issue concealed carry is dead after this ruling. But what about other issues? Well, I want to let the good professor speak for himself.
Explain what other requirements states can still exercise at this point?
Well, one thing that the Supreme Court said in this opinion was that the only gun laws that are constitutionally permissible are the kinds of gun laws we had in the 17 and 1800s, or laws that were sufficiently similar to those laws. And that really calls into question a number of gun laws, and not least of which the Senate Compromise Bill, which includes funding for red flag laws. But we didn't have any laws like red flag laws in the 17 and 1800s, and so that's a kind of law that might be called into question in the coming years.
Okay, moving back to the article, let's look at what Winkler has to say. It's fair to say this ruling will have its biggest effects in a state like California with more restrictive gun laws. This is the beginning of a period where we will see a wide variety of California gun laws called into question, if not struck down entirely. And I would remind you that these laws are almost exactly the same as some of the laws in Massachusetts, some of the laws in New York and New Jersey. They all follow the same template. They all follow each other. So if they're struck down here and it goes up to the Supreme Court, probably they'll be struck down there. So, just what gun laws does Professor Winkler think will fail? Well, specifically, he talks about the following gun laws in the article: red flag laws, magazine limits, assault weapons bans, waiting periods, and age limits above 18. And what does he think will happen to these laws? That's right. He thinks every single one of them will be found to be unconstitutional. None of them have a historical precedent, so none of them will pass the new test that the Supreme Court has laid out. Now, the only law that he thinks might pass constitutional muster would be the background check law. However, in California, that is linked to the 10-day wait. So they'll have to essentially enact a new background check law in California that does away with that 10-day wait if they want it to stand up to constitutional muster. Now, Professor Winkler does make another very good point about challenges to these laws. He says, Winkler said he believes the respective fates of California's various gun laws could largely depend upon the whims of whichever lower court judges hear the challenges. And he's right. If you got a really liberal judge who doesn't care what the Constitution says and doesn't care what the Supreme Court says, they could interpret it any way they want. But if you get somebody who's going to apply the Constitution and the Supreme Court rulings properly, there's no question how it's going to turn out. But what neither Professor Winkler nor the author of the article mentions is the fact that the person and the organization bringing the challenge to the law gets to pick what district they file in, and therefore gets to pick the judge that will hear the case. So, let's meet the judge who will be hearing the challenges to California gun laws. Judge Roger Benitez, Senior United States District Judge of the United States District Court for Southern District of California. Long title. However, gun owners in California have another title for Judge Benitez. They call him Saint Benitez. That's right, Saint Benitez. That's because so far he has issued injunctions blocking California's enforcement of their 10-round magazine limit, ammunition background check, and the state's assault weapons ban. Now, although these injunctions have been stayed or reversed by the Ninth Circuit, and some of them are waiting to find their way up to the Supreme Court, I think it's very clear that Judge Benitez is going to rule according to the Supreme Court ruling that's been handed down. In fact, he was applying this same standard before the Supreme Court held that was the standard. So, what about the Ninth Circuit? What if they decide to reverse his rulings? Well, then they'll be in direct defiance of the Supreme Court, which they were not in before this ruling. And the High Court would likely reach down and correct them, and I think rather promptly. However, let us remember that these rulings have all been very close. In the initial panels at the Ninth Circuit, which are 3 judges, they've typically been 2-1, and they've been close in the 12-judge panels that hear what they call an en banc hearing, which is 1 level up. So it's only going to take a judge or two to decide to follow the High Court's opinion for us to get the kind of rulings we need. So there you have it. Even an expert on the gun control side thinks that this Supreme Court ruling will eventually wipe out about 90% of the gun laws, the worst ones, on the books in blue states like California, New York, Massachusetts, and New Jersey. And my friends, I think this is very good news. Well, if you made it this far, thank you for watching and listening. And I ask you to please consider liking, commenting, subscribing. All of that helps the algorithm, helps to get the word out to more people, helps us to build the channel. I'd really appreciate it. And I will see you in the next video.